But I want to come back here now, dial back now, and come to you and explain to you the courthouse. So I'm walking down the hallway here, take off my hat, walk in, and I'm introduced to Judge Rosado, because everything about her, from the moment I walked in until the moment I left, could not have been any friendlier. Ridiculously nice. She's like, oh, how do I just want to be clear here. Like, how do I pronounce your last name? Like, trying to like make sure I felt comfortable. And I appreciate that, because when you're a justice on the bench there, you don't have to, you can be a jerk. No one can do anything about it. And she was the farthest thing from that. Like, genuinely, ridiculously nice. We sit down there. I sit down, and there's a big table. We're not in a courtroom. Imagine a fancy dining room with a massive table and the judge sitting on one end. I sit on one side, my adversary is sitting on the opposite side. And she asked me how I pronounce my name, and I told her that. And she's like, okay, so the way I think we're going to do this is, since you're the petitioner, you'll go first. You'll explain the basis of your application, and then I'll let your adversaries respond. So I said, okay, thank you. And this is what I said. Said, Your Honor, I am the owner of a company called Good Lawgic LLC. I formed this company to produce content on social media. The type of content that I tend to produce relates to news about politics and the law. A common topic over the last 18 months has been all of the legal embroilments of President Trump. Now, as the court is aware, there's an ongoing criminal action, which just commenced yesterday, where they're beginning jury selection. And he's been charged by District Attorney Alvin Bragg with violating 34 counts of New York Penal Code 175-10. On or about March 26th, Judge Merchan issued what is colloquially referred to as a gag order. That gag order was expanded on April 1st. The petitioners believe that those gag orders are unconstitutional, and that as a result of these unconstitutional restraints on President Trump's speech, we are incapable of collecting information and disseminating it, and this is impacting our freedom of the press. And when we come to the conclusion that it is unconstitutional, is only because a review of Supreme Court precedent makes it rather evident that the court is loath to ever endorse any type of restraint on free speech. In fact, the court has said numerous times that there is a heavy presumption of constitutional invalidity when a court issues a gag order. So, starting with that assumption and recognizing that the only time we ever see a gag order that can, or any restraint on First Amendment at all, be endorsed by the Supreme Court is when we are concerned for the constitutional rights of another. We can look at Shepard v. Maxwell. In that case, where the court saw that the First Amendment rights that are being expressed by the media in their overzealousness in the way they handle the case and their interactions with the jury, that they said, okay, this is now violating the due process rights of the defendant. He can't get a fair trial because there's such unchecked activity, and the court did nothing to stop the interactions from a very aggressive media, which was actively against and working against the defendant's interests, that was interacting with the jury themselves. But the court was very clear in that instance that the reason that they were willing to very narrowly have any sort of infringement on First Amendment rights is because they were concerned about another person's constitutional rights being negatively affected. The only way that the court has ever agreed to in any way impact First Amendment rights has been because there's been a concern of protecting someone else's unconstitutional rights. So when we look at this case over here with Judge Merchan and Judge Merchan and the gag order they issue on Donald Trump and the justification that he provides for this gag order, and he says that I'm instituting this under Landmark Communications versus Virginia. I'm doing it under Shepard v. Maxwell. I'm doing it under Nebraska Association. And every one of those cases has one line after another saying gag orders are never okay. It's never, ever okay. It's not okay. And the only time that they're willing to engage in some sort of balancing test at all is when on one side of the ledger you have First Amendment rights, and then on the other side of the ledger you have someone's other constitutional right that's being very, very grossly impacted. That's the only time we can get to a balancing test. So when Judge Merchan adduced those Supreme Court decisions as giving him license to engage in a balancing test, that was an error of law. He had no right to engage in a balancing test. Once you engage in a balancing test, you can come to whatever conclusions you want as to which is more important. But he had no legal authority to engage in that, and that every Supreme Court precedent comes to the conclusion that he had no authority because there was his interest in his reasons for trying to infringe on First Amendment rights had no constitutional backing of trying to protect a constitutional right of another. And that's why there was a problem. That's why this is invalid. And we see we see that in his application that the courts have been very clear that you need to have a compelling need and that it has to be as narrowly tailored as possible. We never established a compelling need here because Judge Merchan never engaged in an evidentiary hearing. There are so many things that Judge Merchan could not possibly know. He relied exclusively on the affidavit of District Attorney Alvin Bragg, and even if we give credit to everything Alvin Bragg said, everything he said as being perfectly true, it's still lacking sufficient information to actually come to a conclusion that would justify a gag. Because what the district attorney wrote was, at the time that he put out tweets, that there was this increase of negative activity from third parties. And I'm going to tell you something. Obviously, in no way am I trying to justify the abhorrent behavior of others who in how they reacted to this entire situation. But the Supreme Court says we need to know that it's a direct cause of the speech. And if we don't know it's a direct cause of the speech, you cannot give any sort of infringement. We need to know that there's an immense need, that there's a serious harm, and it cannot be speculative. And even Alvin Bragg himself can't know that. He can't know that it was because of something that Trump said in a post, rather than the fact that objectively he is the presumptive nominee to be the next president of to be the next GOP presidential candidate, and all of a sudden, New York, which is traditionally a very strongly Democratic-leaning jurisdiction, is bringing him into court and calling him a criminal and saying we're going to throw him in jail. So yeah, there are a lot of people who acted in ways that I would call immoral, reprehensible, and I would never try to defend. But we're trying to figure out, why did they do that? And we don't know. All we know is that there's a correlation in time with his tweets. It's also a correlation in time with when the charges became public. So even if he sat there mutely the entire time, you might have had the exact same thing. We don't know if now stopping him, whatever effect has been made, even if it was made by that, we don't know if stopping him from speaking going forward is going to have any impact on slowing them down. When you consider all of these different things and you consider the broadness of these orders, where he can't talk about witnesses that we know are talking about him derogatorily day after day, and that no matter what they say, even though he's a criminal defendant, that he's not allowed to respond to it. She's like, yeah, don't go. I saw your part there where you wrote. This is the judge now. So I saw where you shared that. Why did she see that part where I shared about why is that the one thing she saw? I'm speculating here. You want to know why it's the one thing I saw? That's where the big color pictures were, which were showing page after page after page of of Michael Cohen doing these broadcasts to hundreds of thousands of people at a time, and every broadcast is called "Trump is deranged," "Trump goes crazy," like they're killing Trump. And that's why I wanted to have those color pictures in there, because, and that's not, and I'm not saying that in any way derogatorily about a judge. I'm talking it's human nature. If you're sort of flipping through something and all of a sudden you just have 5 pages and you're not expecting to see any pictures, and all of a sudden it just pops out, you're like, what's he putting in here? You can't, no human could avoid looking at that. You have to look at it. It's impossible. I would have been shocked if she hadn't noticed it, because you're just reading page after page, words, boom, bam, bunch of pictures in your face. It's gonna shock you. That's why I incorporated there, because I was like, that's gonna stick out. I want to color. I want to bam, like splash her in the face, and apparently it did. She's like, yeah, you don't have to go. I saw that there was a lot of that. So I said, so for him to not have the right to respond to that he can't say anything, no matter what they say, he's not allowed to respond. It just reeks of unfairness. And I really want to point this out to the courts. Imagine the horror. There's no way this can be constitutional. It's not constitutional because the whole balancing test never should have happened. The application, there's no proof of compelling need, and that this is the broadest imaginable gag. And we saw he even expanded it when as soon as Trump attacked his daughter and said his daughter got millions of dollars from the DNC, Judge Merchan's daughters, he said, you can't go after my daughter, when that's actually an attack on Judge Merchan himself. I brought that up because I knew that the one thing that the judge and district attorney sort of have recognized in the law is that you can't gag him from talking about him specifically. You want to know why it wasn't broader? The reason that there's the obvious exception that you can talk about Judge Merchan individually, you can talk about Alvin Bragg individually. It's because that's some of the Constitution. There's case law which basically says you cannot stop him from talking about the judge. So they basically said, well, we're not allowed to do about that, but we can stop him on everything else. But when he's attacking Lauren Merchan or whatever her name is, the daughter, it's not that he cares about the daughter. It's that the point is that was a reason that that he's calling for corruption. And this is what I said to the judge. I said he's calling out what he deems to be corruption in the judge, but he can't even reference the daughter now because that was an expansion that came on April 1st. So everything that he's claiming here, you can't dispute the fact that this is political speech, which is the most protected speech. The Supreme Court has said over and over again, that's the most protected speech. To say that that this is not political in the context that everyone knows that if you see how people vote, you can pretty much predict how they're going to call this, how they're likely to find in this case. To say this is not political is just, and that his speech about this isn't political. It's like we're pretending we don't see reality here. And I don't know. A reflection after I said it, I was like, I don't know if that was the right call to say that blatantly. I'm not going to kid you. Right after I said it, I was like, let me move on from that. Let me move on from that. So I said, at the end of the day, it's because it's overly broad, because the whole application of coming to this conclusion was in error, because that there's two constitutional rights on one side of the ledger. There's Trump's First Amendment rights and his Sixth Amendment rights, and zero constitutional rights in support of issuing this gag. We respectfully point out that this is unconstitutional, and I just want to point the court into recognizing the following thing. God forbid, if we go through this entire process with the former president of the United States being gagged while he goes through this criminal proceeding and he gets convicted, and then the Court of Appeals or the Supreme Court rules that this gag was unconstitutional, imagine the black stain that comes on our New York judicial system. I've been proudly a servant of this system for the last 25 years. And I will be humiliated if that happens. Because basically what we're saying is, oh, we're going to gag you, we're going to gag a former president and then convict him, and the gag is illegal. It's a stain that will never go away. So for all those reasons, and then I leaned in with, because I was like, and I just wanted to clarify the reason that I'm here is because on the New York Times v. Rothwax, she's like, yeah, no, I understand that, that's fine. New York Times v. Rothwax is what gives the member of the media justification to come in. So she's like, yeah, you don't need to go into that. So I said, all right, and with that, I yield. And that was my oral argument. So I finished my oral argument. And the first guy to go was district attorney. And he blew my mind away. Blew my mind away. You want to hear what he spent the first 5 minutes of his response to me? First 5 minutes of his oral argument was citing case after case after case as to how I have no standing, no legal argument, and no basis whatsoever to move this court to delay Donald Trump's trial. And he had so much law on his side. It was overwhelming. I couldn't believe it. He was going on and on for no less than 5 minutes about how I have zero right. I don't have the standing as a member of the press. I don't have there's tons of case law which says that there's absolutely no basis for there to be a delay of the trial, that I have absolutely no right whatsoever, and that there's no supporting case law whatsoever to justify delaying the trial of Donald Trump. And I sat there throughout like this. And Article 7803 clearly says that it's not allowed to delay a trial. I couldn't believe it. I couldn't believe it. He had a page and a half of notes, and the first 3/4 of the first page was making it very evident. And I had nothing to disagree with him about. I had nothing to say to that. I was like, he never read my papers. This guy never once he didn't make it through the first page of my papers. He literally read nothing of my papers. Nothing. The guy could have been speaking in Tarshish for all the relevance it had to what I was talking about. He didn't even listen to my freaking oral argument. I mean, the guy's sitting there listening to me make my case. Not once did I mention anything about delaying a trial. I don't know if this space cadet was like inside his brain. There's like a Tetris game that's going on? I was like, what the heck is even happening here? What is happening? If he literally was speaking Babylonian at that point in time, it would have been no less effective than anything else he was saying. I mean, the words happened to be English. They were making cogent sentences. They just had zero to do with anything that I had been talking about for 20 minutes. And finally, he started getting in. It's like, I was like, about how this has already been decided, that I as a member of the media have no more standing than anyone else, which means I have zero standing, just like no one else has standing to bring application, that my status as a member of the media gives me no more standing whatsoever. No more standing whatsoever. And there's case law after case law in the Supreme Court, which says that I have no more standing as a member of the media to bring an Article 78 proceeding. And he specifically said that Rothwax is totally inapplicable here. and that this case and that Judge Engoron issued gag orders and they were all fine, and Judge Chutkin in DC issued gag orders and they were all fine, and that I have absolutely no basis whatsoever to be bringing this, and that everyone says that it's totally fine to issue gag orders. And then he got into really was the only part he had to say. The only part that he had to say, which is Donald Trump is scaring the bejesus out of witnesses. We have had witnesses come to us and potential jurors say, I am terrified that he is going to call me out, and they don't want to come forward and they don't want to testify because they're so terrified of what he's going to say and do. They're terrified of him. Those 3-4 sentences, that's really all he had to say. Ignores constitutional precedent, ignores anything about law. It's not a legal argument. It's not any kind of legal argument. It doesn't mean anything. I mean, I guess you can say that there's some sort of justification precedentially, that there's some sort of legal argument that's being made there that, if precedent is established, what's there? There's a Trump law? There's a special Trump law? Because I don't remember reading about that. I don't know. And when I was reading my constitutional, when I was saying common law, I haven't taken a common law class in decades. Maybe there is a Trump law that I'm unfamiliar with, that if Trump is scaring people, people are calling up a district attorney and saying, I'm scared that perhaps maybe the Constitution gets ripped up. I don't know. Second guy gets up there. Now remember, the first guy argued that just because I'm a member of the media, that doesn't change me. There's tons of Supreme Court precedents that say the member media has no different from anyone else. And I agree with him. That's actually technically true. We are not any better. This stupid hollow press credential is meaningless. It is utterly, utterly meaningless. Well, after he went on and on about how the fact that I'm a member of the media gives me no greater standing, the next guy got up and said, this guy's not even a member of the media. He's coming in here and he's not a member of the media. I don't believe that he's a part of the press. We have no evidence of that. I'm literally sitting there right in front of him like this. Like, we have no evidence. He's got some blog on YouTube or something, which he's blogging, and we do not concede that he is considered a member of the media. There's no evidence that he's part of a major organization like CNN, MSNBC News, ABC News. There's absolutely no evidence of that whatsoever. I'm officially recognized. Dude, recognized. And the other guy 10 seconds ago said that it doesn't even matter. So what's happening here? What is happening here? I don't understand anything that's happening here. And he said, this has already been decided. That's what this is. This has already been decided. It's been decided. And Trump himself has brought an application here. And he brought this last week, and the court has decided. It's been decided. There's nothing further he has no great interest here. He has no interest at all. And it's already been decided. It was decided by Judge Engoron, and it was decided by Judge Merchant. And then when Trump came in here for a TRO last week, it was decided that this court rejected his TRO. He's adding nothing new here. And all I'm thinking is, if I added a ton of new things, you just didn't friggin' read it. Instead, you're looking down your nose at me like I'm some sort of poor schmuck because I didn't work for MSNBC or I didn't work for some stupid big firm, and just assume that whatever argument I'm giving out there must be too inconsequential for you to actually give a shred of credit to even bother reading. Not even bother reading it. One schmuck up here thinks I'm talking about getting a delay of the trial. Another schmuck over here is basically saying nothing new added. Really? Show me one damn person who pointed out in any of these stupid arguments that in order to put a constitutional gag on someone, you must be defending a constitutional right. Because I can promise you, none of them did. None of them did. Perhaps he did read my papers a little bit. At the very end of the second guy, the OCA guy's arguments, he goes, I didn't see what my colleagues saw where the petitioner is moving to delay the trial. If that is in fact what he's moving for, I would like to address that now. And he started talking about that. And I was like, and he looks at me, he's like, no one interrupted you. So I said, I just want And the judge politely said, I think he's going to point out, I think the petitioner wants to point out that they're not asking to delay the trial. Is that correct? You're not asking to delay the trial, are you? So I said, no, it never crossed our minds once that we would have that any sort of basis in law to do that. And there's nowhere in our papers. He's like, oh, okay, good. So we can just put that aside. I was like, okay, yeah, you won on that one. What? What does that mean? Why would I be moving? Where would my standing be to come for that? What case law nothing I said had anything to do with that. No, I'm not moving to delay the trial. No, I didn't ask for that at all. No. So I asked the judge for permission to rebut. And she said, I can give you 2 minutes, but I would give you 2 minutes. I have to give each of them 2 minutes. She says, I would. I really don't have time right now. So I said, okay. Well, I appreciate the court's time and thank you. They took us out, told us to go upstairs, wait in the hall there. 15 minutes later, they come out, and we get a ruling from the court which says interim application denied.